The chair calls Jim Pikl, testifying for House Bill 1361.
Chairman, good afternoon, members. I am testifying on behalf of 1361. I am the appellate lawyer in the famous case that's been talked about today, Jim Luce, about his daughter in Fort Worth. Anybody wants the cause number, it's 325-288-594-99. That was asked for earlier. There it is. I've seen firsthand through my own experience as a civil rights lawyer, especially at the appellate level, the harm that unrestrained judicial discretion can cause. The case Luce was involved in is a classic example of that. He missed one 3-day weekend visitation with the grandparents, and he lost his daughter for 37 months until we had to have a jury trial in Fort Worth get her back. A jury trial. We filed, this has been talked about too, we filed 2 writs of mandamus, including one at the United States Supreme Court, trying to get this overturned and trying to get the judge, Catterton, off dead center. I know mandamus doesn't work, and I guarantee you I've never seen a case in 30 years of appellate practice where a court mandamused a trial court to change his docket and try a case on their schedule instead of his. It doesn't happen. It doesn't happen. If you have an unlimited deadline for the trial judges, like we do right now, I'm not even saying they'll abuse it. I'm too busy. I got other things to do. Yeah, you don't have your kid anymore. You know, come back next month. Come back in 6 months. Come back in 2 years. Yeah, and that's what you hear. And like it's also been pointed out here today, Maddie Luce was 8 when she was taken away from her dad. We didn't get her back till right after her 12th birthday. He lost 37 months of her life as parenting her, and there is no recourse or remedy for that, period. He'll never get that time back. This bill seems like nothing really more, all emotion aside, than a gap filler. We've got a 1-year deadline for CPS cases. And by the way, when a child is in the CPS system, there isn't just allegations that the parents of the child did something wrong. CPS has already proved to a judge they did something wrong. You can get a temporary order in this state to take the child away on allegations and not proof. Affidavits, they're not subject to cross-examination. That's when kids get taken away, and that's when Jim Luce's kid got taken away. It was based on affidavits. No hearing, no cross-examination, no live testimony. 37 months. CPS has already shown a judge there's a problem with this parenting situation that runs a risk of harm to the kid. They have to get their case done in 12 months. But a grandparent can come in on affidavits not subject to cross-examination and no proof and keep the kid for 3 years. I agree, we shouldn't pass legislation for the outlier cases, and I'll even concede that Luce's case might be an outlier. But you know what? If you take my kid away for 2 hours, I'm mad about that. I don't care how long it is, especially with no proof, just allegations. Here's a suggestion for a solution. How about this? How about this? How about it's only 1 year if the SAPSER petitioner trying to get the kid away actually gets the kid away? In other words, how about if the parent keeps the child, we can just let it go forever. Just let everybody delay, let the grandparents not be diligent to get the case to trial, let the kids stay with the parents, which, by the way, under U.S. Supreme Court precedent, they are presumed to be fit unless proven not to be. So the kid is not in danger. Allegations of danger are not danger. They're allegations of danger. So how about that for a fix? We only make the 1 year limit if the kid is taken away from the parents. I think that would fix a lot of these problems we've talked about today. And mandamus is not a solution, believe me. That's all I have, Your Honor.
Well, sometimes time limits on courts are good ideas. I think the only time I passed a constitutional amendment had to do with motions for reconsideration before the Texas Supreme Court that could sit around for years.
Yeah.
And now that's no longer the case. We changed it. The voters decided to vote to show that it's now overruled by operation of law after 180 days.
Good job.
So that does happen. Any other questions, members of Mr. Pikl? Mr. Pikl, thank you for being here, and thank you for your help.
Thank you, Chairman. Thank you, members.